Come on up, Mr. Strong. All right, so you understand why you're here today? Why do you think you're here? Because you're what? You're supposed to come to court. That's right. You know this is court. You know who I am? And you know who this gentleman next to you is? That's your lawyer. Okay. You understand that you have a charge here and you're on probation, and the state over here has filed a motion to revoke your probation. You understand that? Have you talked to your lawyer about that? Yeah. You understand what you're charged with? Were you on, do you know, were you on probation? This is an MTR, correct? You got that, you understand, and the state has now filed to revoke your probation. Do you understand that? So you've been a what while you're in jail? That's why you're locked up, yes. Okay. They're saying that you violated those conditions and they're wanting to revoke you off that probation. Now, you've been sent, you went to Terrell State Hospital, is that correct? Right. And you understood everything that happened there. They are saying that you are now competent to move forward. You understand that? And Mr. Jordan, you got any questions for him?
Mr. Oliver, you and I were talking earlier, related. The state's offer at this time is not to keep you on probation. They're wanting to adjudicate you and have you found guilty and sentence you to 2 years in the Texas Department of Criminal Justice Institutional Division. You'd be entitled to have that offset by. You have a lot of back time between being in jail and being in the state hospital. You get credit for all that.
I'm sorry, say that again. Yes, all that time will count. You've been in custody for all this time, all the time that you've been in custody. That would be your back time, essentially. You understand that? Okay, so, sorry, go ahead. It would suffice. It would all be counted, yes. Now, that doesn't mean that you would automatically get out. You would, well, I'll let Mr. Jordan.
But you know what's on, what the offer is today. You understand, he doesn't work in our office anymore. I'm going to be the attorney handling this. Sir, that's up to the judge. I just want to make sure you understand what the offer was.
Well, Mr. Jordan is your attorney, and he is representing. Mr. Jordan is a very competent attorney. He's who the court has appointed to represent you. Understand that? So that what happens, here's how this works. Is the state filed their motion to revoke you. You were appointed an attorney. They decide what it is they want to offer you. They've made an offer of 2 years, okay, for you to be in custody. Obviously, you have been in custody for quite some time now, and you've been also sent to Terrell State too. You understand that? If you decide to reject their offer and you want to come to me, right, the range of punishment that I can give you is from 2 to 20 years. Well, you understand? They're offering that 2, and that's all I can give you, the least I can give you is 2. The most I can give you is 20 if you decide to come to me. You understand that? I would advise you to speak to your attorney about that.
But you do understand, we're talking about a 2-year incarceration sentence, not 2 years of probation. And that's why I'm concerned we don't understand what the offer is.
Obviously, that is not true. Okay, now, I'll let your attorney talk to you about what actually that means as far as the 2 years. Because I can't go into that with you, but what I want you to know, to be clear, you have 2 options. Okay, one option is to accept what the state is offering, all right, or you can reject that offer and you can have a hearing in front of me, and I decide what to give. Okay, the range of punishment that I have at my disposal to give to you, if I decide that you should be revoked, is anywhere from 2 years all the way up to 20 years in the penitentiary. You understand? I'm sorry? Well, you understand, the lowest I can give you is 2 years. I cannot give any lower than that. All right, you got it now? Okay, I just want to make sure you understand, your attorney wants to make sure you understand. Obviously, you've had some mental health issues in the past. We want to make sure you've come back and you're deemed competent now, right? And so we want to make sure you understand that, all right? Okay, all right. Why don't you just have a seat, Mr. Jordan, talk to you, okay? All right, thank you, sir. Where did Bill go?
He's
Good.
right behind us.
Yeah, Jacavian Wilson.
He's gonna apply for a lease after a year.
Keep that in my file.
Thank you. I'll remind you.
I'm sure you will. All right, this is cause number 200021186 F style state of Texas versus Jacavian Wilson. Is that you, sir?
Yes, sir.
And Mr. Cox, you waive arraignment, read the state's indictment.
I do not hear, here's no contest.
And Mr. Wilson, can you read, write, and understand the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
You understand that you have an absolute right to a trial on this case. However, by entering into the deal with the state, you're waiving that right.
Yes, sir.
Did you understand everything you signed?
Yes, sir.
Did you go over everything you signed with your attorney?
Yes, sir.
Been charged by way of indictment with the 3rd-degree felony offense of possession of controlled substance. 3rd-degree felony carries a range of punishment from 2 to 10 years in institutional vision. Knowing the range of punishment which you're charged with, you pled no contest. You understand that? You understand I will treat that the same as I would a guilty plea. You understand this? Are you doing that freely and voluntarily? Their recommendation from the state.
Yes, in exchange for the plea of guilty, the state recommends 3 years deferred adjudication, $500 fine for costs like substance evaluation.
Is that your understanding of the state's offer?
Yes, sir.
You understand by accepting the state's offer, you're waiving your right to appeal. You'll have no right of appeal.
Yes, sir.
Anything from the state?
State would like to offer states one is not stipulation of evidence, states two, showing regular consequences.
No objection.
States 1 and 2 will be admitted.
Thank you. for the rest.
Question closed, Your Honor.
Both sides that rest closed will find the evidence sufficient to find you guilty. I'll prefer finding you guilty. Place you on community supervision for a period of 3 years. Assess a fine of $500 court cost and the restitution. Did you go over the conditions of probation with your attorney?
Yes, sir.
And I know he told you that he,
I'm
There's
sorry,
2 cases, Judge.
There's 2 cases. So that would be one of them.
Everybody's correct.
Okay. Same thing on that one. That's a possession of marijuana. Your same range of punishment on that one. What is your, please, no contest on that one too? And that's on cause number 19-800-3386F. And you understand you also have a right to a trial on this one, but you're waiving that. And you're waiving your right to appeal. You understood everything you signed. That's when you went over everything. And recommendation stay on this.
Yes, sir. In exchange for the plea guilty, the state recommends 3 years to term.
You understand, by accepting that offer, you're waiving your right to appeal. You'll have no right to appeal on this one. Yes, sir. Anything from the state on this one?
State law, which states one is not stipulation of evidence, the state.
Section 1, 2 will be admitted.
Question closed. Your Honor.
Both sides at rest closed. We'll find the other petition, find you guilty of defer, finding guilt, place your community supervision for a period of 3 years on both counts. Would be a fine on each cause. It'll be court costs only on the possession of controlled substance, and there will be restitution. Go over the condition of probation with your attorney. I know he told you, even though you're not being found guilty at this time, if you violate any of those conditions, state can file a motion to adjudicate you, and you can still be sentenced all the way up to 10 years. You understand? Make sure you follow this. Yeah. All right. And copies or something. Bobby will tell you what to do.
Yeah, we'll do you right. Still, that's okay, that's okay.
On that case, you're talking-
I'm paying attention to the second.
Yeah.
Yeah, we do a couple.
Wow. I mean, bailiffs administered it?
They're CPR, but they have to be on the file. CEOs. They're used to really work for them.
Holy cow.
Well, his partner Jeff Lehman,
They
Bob
have to-
Chow, and Frank Sierra, that's the detective that just they were in trial. But he just killed him.
Start with that.
And they brought him back and brought him to the hospital. We got 2 stents.
Hospital.
Yeah,
He's not-
he's not even that old.
No.
He's
dead,
early
right?
60s.
I mean,
Yeah,
he's-
50.
Pretty
Late
fit.
50s, early 60s.
The bailiff that ripped off his shirt in the CDC force said he's not that
Right.
Well, my goodness, that's, glad to hear that.
bad. Big guy in the parking lot, he did. I mean, he had it in the parking lot, he did.
Yes, absolutely, especially in that part.
Somebody run you over.
People just walk right over you there.
Honestly, but
Yeah. Just another, yeah. That is,
quite a story. And you know what? There wasn't anything in the news about it. You know, that's certainly news for it. Like, how much? Bringing a guy back to life
in a jury trial.
in the jury, well, the jury's in the hall. It's just not really jury.
So this was right before board iron and everything. I didn't.
You
I didn't.
didn't work out?
They'll keep the file.
Okay, thank you.
Him, the copy for probation.
Which it doesn't matter. You got-
Mark, will you get that? Walter was gonna get him, I think. The one you talked about.
Labor, I mean,
Oh, no, I'm sorry. That too, we can do that. You want to do that real quick, we can do that. And then I also have, oh, where's the attorney on the, yes,
He's in the hallway.
I'll wait on. If you want to do that witness real quick, I'll do it. Come on up here, sir. Tell me your name again, sir. Sir, you know, I know we've already talked, all right? You have been subpoenaed to be here. That's October the 25th, October the 25th on a capital murder case. And you were sworn in, and I just want to make sure you're clear. Been subpoenaed, you've been sworn in, I ordered you to appear. And yet the state has still had trouble getting in contact with you. So they subpoenaed you today to be here. Obviously, you showed up, and that's good, because if you hadn't, I would have issued a warrant for you to be here. And you know, I can hold you in contempt. That could be all the way up to 180 days for failing to comply with a court order. You understand that? I want to make sure the state obviously had a big interest in making sure you understood what the repercussions would be if you choose not to be here on October 25th. You understand that? I do expect you to be here, and I will let you know if you're not. We'll be getting an escort here, and we'll be sitting in jail for one. You understand? Any questions on that?
Then you understand that it's not like we don't show up in case things go delay. That kid stays pending. They fired you.
Yeah.
And Judge, can you make sure that he understands he's sworn in for this whole incident being the 4 different defendants? Do we need to go and formally swear him in for all 4 cases? Just to make sure, because
Well,
they're all
I
set
would
for
be,
trial.
I would be following that. We do that. I don't have a problem doing it. As all of them are set for trial.
Right.
Y'all would need to give me files on that. And we have to make docket entries on each of that. Just have a seat, sir, and we'll swear you in on those items. All right. You can sit here. Amber Benson. Come on up. Come right up here, man. Stand right up by that table. That's good. All right, this is cause number 219005486F, Style State of Texas versus Amber Benson. Is that you? And Mr. Russell, do you waive arraignment, read the states and that?
I do.
And Ms. Benson, can you read, write, and understand the English language? You're a U.S. citizen. You understand that you have an absolute right to a trial in this case. However, by entering into the deal with the state, you're waiving that right. Did you understand everything you signed? Did you go over everything you signed with your attorney? You're actually pleading to a Class A misdemeanor assault causing bodily injury. Your attorney state agreed to reduce this to a Class A misdemeanor, which carries a range of punishment up to a year in the county jail. Knowing the range of punishment which you're pleading to, the Class A assault causing bodily injury and with family violence finding. Knowing that, how do you plead guilty or not guilty? Plead guilty because you are guilty and no other reason. Is anybody forcing you to do that? Wants to take this deal, is that right? Why don't you ask your attorney side there? All right. The recommendation from the state.
Fine, $460 per cost.
That's your understanding of the state's offer. And you understand by accepting their offer, you're waiving your right to appeal. You have no right of appeal. Anything from the state?
Say we're not going to see.
Objection. Stage one will be admitted. The court will take judicial notice. Please raise your right hand. You solemnly swear the testimony you're about to give this case will be the truth, the whole truth, nothing but the truth. So help you God. Please lower your hand. Mr. Russell.
State your name.
Amber Benson.
Ms. Benson, I've been appointed to you since about May, correct?
Yes,
We met a few times up here in court, correct?
sir.
During that time, we looked over the offense report, and we discussed your side of things and what the law is, correct?
Yes, sir.
Today, you were offered this deal that we just went to, correct?
Yes, sir.
Like you had enough time to consider that?
Yes, sir.
Now, the one I know that you had was that when I told you there was family violence finding, and I told you that you can no longer own a gun or ammunition, correct?
Yes.
Wanted me to ask the district attorney to waive that.
Yes. It's just for hunting season.
Okay, I told you that you're not willing to waive that. And so you still wanting to proceed with it,
It's in my best interest. Yes.
and you're satisfied with my representation.
Yes, sir.
That's what-
Both sides are supposed we'll find the evidence sufficient to find you guilty. I'll follow that offer. Further finding of guilt, place you on community supervision for a period of 2 years. Assess a fine of $750 along with the court costs. You go over the conditions of probation with your attorney, and there will be a family violence fine. You understand that if you violate any of those conditions, they can file a motion to adjudicate. You still find you guilty, and you can still be sentenced up to a year in county jail. You understand? All right. Make sure you follow those. All right. Good luck to you.
Yeah.